Good afternoon. This is the origins of the doctrine of discovery and its implications for Indian country today. The Indian Land Tenure Foundation is very proud to host two distinguished scholars as we begin our conversation today on the doctrine of discovery and understanding some of its historical and philosophical underpinnings, in addition to some of the aspects of how it impacts many of our lives today. Joining us, we have Robert Miller, who is a Willard H. Pedrick Distinguished Research Scholar, Faculty Director of the Rosette LLP American Indian Economic Development Program, and Professor of Law at the Sandra Day O'Connor College of Law, Arizona State University. We also have Lindsay Robertson, who is the Faculty Director for the Center of the Study of American Indian Law and Policy, the Sam K. Viersen Family Foundation Presidential Professor, and the Chickasaw Nation Endowed Chair in Native American Law in the College of Law at the University of Oklahoma. Before we jump into the agenda for today, I wanted to lay out a few ground rules so that everyone knows what's going on. Everyone is muted, but you can still enjoy. You can show your video or not, but you can enjoy the presentation as it is. Any questions you have about the content that's being covered, or questions that may be related to some of the content that's being covered, please type them in the chat. You can do that immediately. And so I strongly encourage you to get some of those questions as you're thinking about them through. I prefer if you do send those to us via this chat surface instead of through a private email to myself, as I'm not checking that right now. Any questions that we can't or are unable to answer at the moment, though, our very talented speakers have been able to, or will be able to, provide a written response for some of those questions. Later in the chat, you'll also be sent a few links to some of the books that both of these presenters have written on this very topic. And I strongly encourage participants to take a look at that and to really, throw themselves into some of this topic. All right, so without further ado, I will first hand this over to Professor Robertson to begin our first segment of the presentation today. Professor Robertson.
Thank you, Nicholas. It's wonderful to be here. It's great to see everybody. I have an initial disclaimer, which is I'm in the Southern Plains. Some of you may be as well, or otherwise in the middle of the country. And so we have been the land of rolling blackouts and snow and really cold weather for the last few days. I am, because the entire front half of my week got pushed back to today, tomorrow, and Friday, I'm going to have to cut out a little bit early. I apologize for that in advance, but I'll be here to sort of do my presentation and answer any questions that you guys have before turning it over to my colleague and good friend, Bob Miller. We are actually going to take the topic that Nicholas developed and divided in half. I'm going to talk about the history of the discovery doctrine, Johnson versus McIntosh in particular, and then Bob's going to devote most of his time to exploring consequences for Indian country and indigenous peoples around the world today, because as you'll see, and it's a point that I'm sure he'll discuss since he's written widely in the area, more widely than anybody, the discovery doctrine has sort of infected the planet and the rights of indigenous peoples around the world, especially in English-speaking countries, but not exclusively so. So, all right, let's talk about Johnson versus McIntosh. See, if you were my class, I'd ask how many of you read the opinion. But since you're muted, and I can't see most of you, I have no way of knowing how many of you are nodding. And yes, I know the case. I'll give it to you fairly quickly, sort of intro to federal Indian law class. Johnson versus McIntosh is the 1823 Supreme Court decision that gave us the discovery doctrine that adopted into American law this discovery rule that explained what the consequences, the legal consequences under US law were of the discovery of the New World by Europeans. In other words, when that guy with the puffy shirt and the flag or the cross planted it in the beach and said, "I claim these lands in the name of whoever the reigning monarch was," what did that mean? What did that actually accomplish as a matter of law, according to the Supreme Court of the United States, again, in 1823? The room behind me, I'm not actually there, sadly. I'm stuck in my house where I've been since March 2020, is the old Supreme Court chamber. This is the room in which John Marshall read the opinion in Johnson versus McIntosh and many of his other major cases. And you can visit it. It's in the US Capitol. It's downstairs. So I'm going to keep that up, but I'm going to flip around because there are a couple other maps that I want to show you while I'm talking. So Johnson McIntosh, my acquaintance with this came, I started teaching Indian law at the University of Virginia Law School in the 1990 to 91 school year. And I was teaching as an adjunct, and I practiced Indian law in DC, and I had gone back to grad school to study history, to get a doctorate in history, which I eventually did. And one of the very first cases that you study in an Indian law course, if not the first case, of course, is Johnson versus McIntosh. And so I had taught this course almost straight out of the gate, decided, this is kind of interesting, and I'm going to abbreviate this story in the interest of time. I thought maybe I'll write an article about this, because you're supposed to write articles if you're interested in going into legal academia. And the article was going to answer three questions: who's Johnson, who's McIntosh, who cares? And that's how it started. And of course, you jump into the literature, and immediately I realized that there isn't any answer to those questions from contemporaries. That about 100% of the scholarship at the time was explorations of the language and pieces that began, well, Marshall must have intended, or this is what this must mean, and this sort of thing, all of which was really interesting, but it wasn't what I was interested in doing, which was figuring out who McIntosh is and who Johnson is, and who cares? And what did they think about all this stuff at the time? So I embarked on what turned into a 14-year journey to find answers to those questions. The results are in the book that Nicholas kindly mentioned, which are more than welcome to read. I encourage you to, and share your thoughts and disagreements and everything else. It's called Conquest by Law, published by Oxford University Press in 2005. And the only part of the story that I think turned out to be especially fortuitous and important to my project was after mucking around trying to find primary documents, which did not exist in one place, which made writing the who's Johnson, who's McIntosh story really, really difficult. I stumbled upon in Pennsylvania at the Historic Society of Pennsylvania Library, an old card catalog, a reference to a de-accessioned document, or a couple documents reclaimed, I learned, by the family that had briefly lent them to the Historic Society of Pennsylvania. I tracked those folks down. I got contact info from the phone book, called them up, went out, and it turned out that they had in their possession not one or two documents, but the entire corporate records of the plaintiffs in the Johnson versus McIntosh case. Hundreds of documents, never seen or cited by scholars because they had spent most of a couple centuries in the possession of the family. They are now, if you're interested, in the rare book room, rare book and documents room at the University of Oklahoma Law Library. And if you are interested in seeing them, we put them online. So those of you who are enthusiasts for the discovery doctrine, you're interested in seeing the plaintiff's records from the case, which include, I'll tell you, references to bribing members of Congress, throwing the litigation. I'll talk about this in a minute, and all sorts of other absolutely fascinating things. You can see them online. They are the Illinois and Wabash Land Company papers, and you'll find them on the website for the University of Oklahoma Law Library, and encourage you to take a look at them. They're tagged, so that makes them at least somewhat searchable, but you can see the original documents and maps and all sorts of fun stuff. Now, okay, so that gave me a story that turned into much more than an article. It turned into a book and a 14-year project, sort of an in-the-weeds analysis of the Johnson litigation. And I'm going to give you the high points of the results. But again, if you're interested, and there are variety of places you can find the story, but the book has it most completely if you're interested. The Illinois and Wabash Land Companies, plaintiffs and Johnson, were two land speculation companies that organized in the 1770s, just on the eve of the American Revolution, in order to take advantage of something that King George III had done, which was issue a proclamation in 1763 at the end of the 7 Years' War, which was mostly England against France. I'll shift now, saying we got all these French claims, and that's the pink lands, in North America at the end of this war. Spain got all the lands that are gold, and the English colonies are on the East Coast. Those lands are occupied by native nations, and you colonists who just won this war, they got Canada too, by the way, but you colonists who just won this war, I get that you're really eager to go out and take those lands, but I don't want you to, because you're just going to start another war. So the proclamation of 1763 said that the lands west of the Alleghenies, that's the mountain range, are reserved to the Indians under our protection, the King's protection. No royal governor has power to issue titles, and no colonists have any right to even go out there. You'll be trespassing and outlaws, etc. This unsurprisingly infuriated most colonists who had fought the war against the French in order to gain access to those Indian lands, and will be one of the principal causes of the American Revolution. But it turned out to be a golden opportunity for some colonists who had the wherewithal to figure a way around it. And one such group was the Illinois Land Company, and another was the Wabash Land Company, which combined. They ended up sending an agent to England who got a former British legal officer, Lord Camden, to provide them an old legal opinion he had written, and they strategically edited it to make it sound as if it applied to these proclamation lands, and overruled the proclamation. The agent for the land companies then took that document. They gave shares to Lord Camden, of course, went out west of the mountains, and I'll show you where on this map, which is from 1793. It's basically, you see where the Ohio River and the Mississippi run together. It's the juncture just north of it, and then the Wabash River flows into the Ohio down here. So it's lands on either side of the Wabash River, north and south of the city of Vincennes. That's the Wabash Purchase, and then they came out and bought lands using on the authority of the same sort of doctored legal opinion from the various Illinois nations along the Mississippi, or along the Illinois River, which flows into the Mississippi down here on either side of the little then existing town of Kaskaskias. These purchases were flatly in violation of the proclamation of 1763. They crossed their fingers that they'd get away with it because they had this bogus legal opinion. And also because the first of these purchases was made in 1773, the second in 1775, against a backdrop of deteriorating American-English relations. And the thought was that in the chaos of the American Revolution, no one's going to look too closely at our legal claims. So they registered these deeds. They were for millions of acres, and then sat around waiting for the revolution to finish. It did, of course, and the U.S. wins its independence, and shares are transferring around in the Illinois and Wabash land companies, eventually picked up by a bunch of prominent revolutionaries who will then, once the new government is established, the Confederation Congress, start desperately petitioning Congress to recognize their title to these lands. Not that they want to live there, but they'd like to be able to sell them and make some money on them, despite the fact, hoping that no one would notice that they were illegal under the Proclamation of 1763, or if they did notice that they were, that they would find the proclamation unconstitutional under the British Constitution as an abuse of the king's power. And part of the reason that we fought the revolution, of course, was that we thought George III was abusing his power. So the first part of the story of the Illinois and Wabash land companies, which will become the Discovery Doctrine, is buying the lands and then riding out the revolution. The second part is 50 years of petitions to the United States government, first the Confederation Congress, and then a series of petitions to the House of Representatives and the United States Senate, trying to get them to recognize the validity of their title. All sorts of objections were raised to it by various congressional committees along the way, none of which, by the way, was the Discovery Doctrine. They included instead things like you bought from the wrong Indians, you didn't pay them enough, so it's insufficient consideration. The maps are impossible to understand. We don't know where these lands are. Those were the three principal objections, but they never got a vote against them by Congress collectively. It was just one committee or another. And so they just kept waiting, withdrawing petitions, filing them until eventually the lands came within the limits of a state. First, the state of Indiana, then the state of Illinois. And the reason that was important was that the states had federal courts. And those US courts, they weren't just territorial courts, they were US regular federal district courts, had an appeal route to the Supreme Court. And so what they had decided by this time, this is 1818, was, we're not getting anywhere with Congress. What we need to do is file a lawsuit to get our title recognized judicially. And then we can take that judicial opinion and force Congress to compensate us. And this had been done before by a different land speculation company, the New England Mississippi Land Company, in an 1810 case called Fletcher versus Peck. So they knew this was a strategy that would work. So they went ahead and filed. They filed first in Indiana, which was a state before Illinois. The judge presiding over the case did not trust them farther than he could throw them. He was a guy named Benjamin Park, who knew these guys well. He had been a legislative agent for the Illinois and Wabash land companies ages before, so he refused to hear it. They threatened to impeach him and then dropped that plan when Illinois was admitted, and so they moved over there and filed a lawsuit in Illinois that will become the case of Johnson versus McIntosh. Now, this is where we get to the part in the story where I get to tell you who Johnson and McIntosh are, because they haven't really appeared yet. We've just got this endless attempt at gaining some sort of recognition for this illegal, under English law, land speculation. Well, McIntosh is the first guy to enter the picture. The companies sent agents out to find a willing defendant. They figured for the plaintiff, we'll just pick some guy who's reputable, who's a shareholder in one of the companies, and to get him out of the way, they ended up picking a guy named Thomas Johnson, who had been on the Supreme Court of the United States. Who better? Now he'll die before the litigation will get going, and so his heirs will take over, his son and his grandson, Johnson and Graham, and so they're officially the plaintiffs. It's called Johnson and Graham's lessee versus McIntosh. And who's McIntosh? McIntosh, my favorite character in this whole story, and his tale, again, is in the book. I'll give it to you in short. He was a Scottish soldier in the British Army during the American Revolution. He decided to stick around once the revolution was done, moved to Vincennes, Indiana, became land speculation partner with the territorial governor. Once the Indiana Territory was established, one William Henry Harrison, whom some of you will remember as the 1-month president of the United States, eventually will die of pneumonia. Harrison was also engaged not only in land speculation with McIntosh, but in buying lands from tribes in the area, including some of the same lands that the Illinois and Wabash land companies had purchased from the same Indians who sold them twice. And McIntosh thought that Harrison was abusing the tribes, that he was taking advantage of them, negotiating at gunpoint. And this thing said so publicly, got sued for defamation by Harrison, lost, and ended up leaving town, moving down to the Illinois side, what are called the Grand Rapids of the Wabash. McIntosh, meanwhile, had married an African-American woman named Lydia, who later was accused of being an escaped enslaved woman from Virginia. And she was a badass too. She's another one of my favorite characters. I spent several days going through court records in Vincennes and discovered that Lydia was a criminal defendant during this period more than anybody else in Vincennes. And it was always for battery. That she was basically, I guess, getting harassed and going around beating people up. And so somebody will have to write their story. Someday they moved down to the Grand Rapids of the Wabash, mad at everybody, and they are discovered there by the agents for the Illinois and Wabash land companies, who pitched them this idea: hey, how would you like to stand in as a defendant in this land claim that we're going to file? The result of which would be basically to eliminate land title claims, if we win, for all of the people who gave you a hard time. And McIntosh said, I'm in. And so he was. And so here's the first thing to know about the case of Johnson versus McIntosh. It was a collusive suit between McIntosh and the Illinois and Wabash land companies, the nominal front being Johnston and Graham, the heirs of former Supreme Court Justice Thomas Johnson. What did McIntosh do? Well, he sat down. I don't know that he put much time into this. The lawyer for the companies, a guy named Robert Goodloe Harper, sat down and pulled out every rejection that the companies had ever received from the Continental Congress or the US House or Senate committees, listed all of the grounds out, and then stipulated every one of them away. So McIntosh agreed that they had bought from the right Indians. McIntosh agreed that sufficient consideration had been paid. McIntosh agreed that it was easy to figure out where the lands were. And the reason that this mattered is that these the court considered factual matters, and under the existing rules of procedure, then, I guess as now, if the parties agreed on facts, and they filed a stipulation of facts here, then the court was powerless to contest the facts that had been agreed to between the parties. And this was a way of shaping the litigation around one question, and they're going to win before the Supreme Court. That's the goal. And the one question is the legality of the purchases under the Proclamation of 1763, which really converts, and did in the early stage of the litigation, to the question, was the Proclamation of 1763 constitutional under the English Constitution? And they were confident that the Supreme Court, which included a bunch of Revolutionary War vets, would say, hell no, it wasn't constitutional. Parliament might have told us we couldn't buy Indian lands, which is what the proclamation did, but the king had no power to tell us we couldn't buy Indian lands. That was unconstitutional. Purchase is valid, no factual objections. Illinois and Wabash land companies win. And since the US had already bought the same lands, we'll just need to write you guys a big check. And that was the plan. Now, at this point, you should be, those of you who read the case, scratching your head, because what is this business about the constitutionality of the Proclamation of 1763? I don't even remember that from my Indian law casebook in law school or whatever. And it's in there. You have to hunt for it. It's deep in there. It's one paragraph. And the court found that actually the proclamation was constitutional and constituted an additional bar to the company's purchases. That should have been, based on the question presented, the whole of the Johnson-McIntosh decision, and we should not be sitting here talking about it today. Because if that's all it had been, who would have cared? We wouldn't have, certainly. So, but that's not all there is, because the first 20 pages or so of the Johnson-McIntosh opinion, before you get to this little paragraph, is the discovery doctrine. And the second thing I want you to know about the case is the discovery doctrine is immaterial to the decision in Johnson versus McIntosh. We talk in general, those of us in this field about, what's with the discovery doctrine, should we keep it? And so it's part of what I want to do is highlight for you problems with the litigation that might cause you to think, maybe this isn't such a good rule after all. One is it was a collusive lawsuit. Two, I haven't gotten quite as well, I'll talk about that in a minute. Two is, well, I guess I will say something about that. Two is, and this is something that I discovered looking at the papers that you can see yourself online, the lawyers for McIntosh at the Supreme Court were actually hired by the companies to throw the case. It was a miracle that they won. Well, miracle was unrelated to, it was related to things other than things we've talked about, as I'll discuss in a minute, that they won. But their job was to go and screw the argument up and lose so that the company could win. So that's problematic too, it seems to me, when one side is paying the attorneys for both sides. And then three is this business about the question presented having nothing to do with discovery, and the discovery doctrine really being immaterial to the resolution of the question presented. So the discovery doctrine is in there. And Bob will talk more about elements of discovery and stuff. I could shorthand it by saying that what the court finds is that the legal consequences of European discovery were that the discovering sovereign, European sovereign, upon discovery of indigenous lands, acquires ownership of the underlying title to those lands. The indigenous peoples retain an occupancy right. The occupancy right is alienable, can be sold or given away, but only to the same discovering sovereign, which is essentially the rule that you'll get when Congress passes the Trade and Intercourse Act in 1790. So restraint on alienation, investing of title. That's kind of the discovery doctrine in a nutshell that Bob has, I think, helpfully teased it out in other areas. So that's there. And of course, what that meant, the court says, John Marshall says, is that, and we'll go back to the court, is that the tribe didn't own the title to the land. The tribes that sold to the land speculators, they only owned an occupancy right, so they couldn't have sold them the land. And they couldn't have sold them the occupancy right either, because that could only be sold to the discovering sovereign, and that wasn't these land speculators. And then there's a bit at the end, which I think is kind of snarky. If you guys, if you got a complaint, go complain to the tribe because they got paid twice, and maybe you can get your money back from them. This is a question that should be resolved under tribal law, is the nicer way of saying that. Now, that raises a couple questions. One, which I'll turn to in a minute, is why is it there? The other is where did it come from? And I want to answer the where did it come from part first, because it's yet the next reason to be distressed about the discovery doctrine. If you read it, and I confess, I was obsessed with this for the time that I was spending working on it. And the answer to this question came as another fortuity when I was working at the Swarthmore College Library outside of Philadelphia, and I got hungry, and it was lunchtime. And some of you have done this before when working on papers in school. I decided, I'm going to go out and eat my sandwich, and 3 steps out, started feeling guilty. I really should be reading something. If I can't, I have no time to waste, and so I froze, and my head went left, and there at eye level in the stacks was a book that said Life of Washington, and it looked really old. And I thought, well, I don't know anything about George Washington, and I probably should, because I was in a doctoral program focusing on the history of the early American Republic. So I grabbed it and I went outside and I sat down and I opened it up. And the first thing I discovered was it was really the life of George Washington during his time as commander-in-chief of the American forces during the American Revolution, and that it was written by John Marshall. And I thought, and yeah, it turns out it was written by the John Marshall. It's the only book Marshall wrote. It ended up being, I think, 3 volumes. Marshall, it turns out, was a terrible historian. There's an apology at the beginning of book 1 where he says, look, you know, I did the best I could. I wrote this book because my colleague on the court, Bushrod Washington, who was George's nephew and heir, told me I had to. And I like George, I knew him pretty well, but I didn't really know how to do this. So it was supposed to be the revolution, but I decided you can't really understand Washington as a general unless you understand like the history of his life. And so version 2 started, Washington was born, and then I stopped and thought, you know, you can't really understand Washington's life unless you understand the world into which he was born. So try 3 starts with the founding of the Virginia colony. And that, I don't know how far he got in because Marshall decided pretty early you couldn't really understand the Virginia colony unless you understood. And you get where this is going. So the life of George Washington during the Revolution begins with Columbus's discovery of America. So 1492. And I don't even think Washington appears in volume 1 of the life of Washington. But what volume 1 turned out to be was, I think, the first comprehensive English language history of the colonization of the Western Hemisphere by Europeans. And that was kind of interesting. Oh, and by the way, I said apologies. Marshall also said, look, I have access to no primary sources. I am, for God's sake, the Chief Justice of the United States. I've got like 100 children and a sick wife. I have no time to do this properly. So basically what he ended up doing was a cut and paste job from books he had lying around the house. And that's how he put this history together. The kindest review, I looked up reviews, the kindest review, contemporary review I could find of this book said, this is a quote, "The Chief Justice will add little to our literary reputation as a nation." That's the kindest review I could find. And then there were a whole lot of reviews that just trashed the guy and the book. And I think he was embarrassed by it. Now, why does any of this matter? Because as I sat down with my sandwich and started reading this thing, I realized what I was reading was the history portion of the Johnson versus McIntosh opinion. That, and you'll know this if you've read the whole of the opinion, there are no citations in the history of English colonization portion of the opinion. There's just this charter and then this explorer and this explorer, all these paragraphs joined by conjunctive sentences that say, and here's it here, and the English adopted the discovery rule. And here's this that shows that the English adopted the discovery rule that I sort of laid out a minute ago and that Bob's going to talk about. And here's another paragraph that evidences this. I recognize them on reading it. If you're interested in this, I don't remember if I put this in the book, but years ago I did a piece for the Virginia Journal of Law and Politics from the UVA Law School. And it's a side-by-side paragraph from Johnson McIntosh next to the paragraph from The Life of Washington, Volume 1, from which Marshall stole it. So that's why, of course, there are no citations. That's also how he was able to write this history so fast, because there's hardly any time between oral arguments, like 5 days or something, between oral argument and the issuance of the opinion. So there's no time to go research the history of, you know, Cabot's discovery of whatever. He's back at his office, he's got his own book there, and he's simply cutting and pasting from himself, from his own badly researched history of the colonization of the New World. So that's the next thing that ought to concern you about the discovery doctrine, because it's grounded in Johnson in junk history. There's no attempt made by Marshall, because he couldn't, to actually go look in European archives to see if any country actually did what he says they did. We got these charters, but in a future case, Worcester versus Georgia, he's going to change his interpretation of what those charters actually did. So there are lots of unanswered questions as of Marshall's time as to what the rules actually were, but Marshall wants this to be the rule. Now, next question, last question I'll take time for is why, and I'm gonna answer that really quickly. This figuring out why he had gone to this trouble turned out to it took me years to do. There's a theory floating that you'll hear, you know, that, well, it created a by limiting the potential purchaser pool, it created a more easily regulated market in Indian lands. The challenge of that interpretation is that there was already a statute that did that. The Trade and Intercourse Act passed in 1790 and repassed, and on the books at the time, Johnson was issued, already said only the US could buy Indian lands. So it really had no effect in that way, limiting the potential purchaser of Indian lands. But it's important to think that through, because what it did do was to limit the potential purchaser group retroactively. So it meant that back during the English colonial period, only one person could buy, that was the monarch, and the other, and this is what I ended up deciding was really what was going on, by holding that the underlying title vested upon discovery in the discovering sovereign, what that did was to validate as property transactions grants of land made by independent states during the Revolution, during and after the American Revolution, to their soldiers. And without getting into too much detail on that, my conclusion after years on this, and this is all in the book, and you can agree or disagree, but I think the case is pretty solid, that what was really going on is Marshall was dealing with a contemporaneous case, not before the court, involving land claims of Revolutionary War, Virginia Revolutionary War veterans to lands in southwestern Kentucky that had been until 1818 Chickasaw lands. And they were engaged in a war basically with grantees from the state of Kentucky, which had become a separate state in 1792. And I could get into the details for the legal detail, but they're all in the book, and I don't want to take Bob's time up. And as I say, unfortunately, I'm going to have to run. But it does resolve that, and it isn't essential to Johnson McIntosh. It is, Marshall believed, essential to resolution of the Virginia-Kentucky dispute, and contemporaries understood it as being related. People got really mad. Thomas Jefferson, in fact, very shortly after the Johnson McIntosh decision is delivered, will write a letter to his Supreme Court appointee, William Johnson, excoriating Marshall for, and this is a paraphrase, this practice of Marshall's of using one opinion to decide a case not before the court. And that, I believe, is precisely what happened in Johnson versus McIntosh, and why Marshall chose to adopt the particular formulation of the discovery doctrine that he chose to adopt in that case. Now, last thing I'll say, I believe that Marshall thought that we would never hear again of this case once the Kentucky-Virginia dispute was resolved, as it was, because there were no more lands out there that states had granted while in possession of tribes. The Trade and Intercourse Act took care of the limiting the universe of potential purchasers to the federal government. So how would this ever come up again? And of course, that turned out to be a terrible miscalculation, because 5 years after Johnson, the case is discovered by the state of Georgia, which is desperate to clear the Cherokees out. The governor of Georgia sees this thing, hauls the opinion into the Georgia legislature and says, look, there's this case here that says that the discovering sovereign owned the underlying title acquired by discovery, the underlying title to Indian lands. That was England for the Cherokees. Now it's us because we declared independence. So Georgia owns the underlying title of the Indian lands. That means, what's the analog? That's like, we're their landlord. We own the building and they have a right to live there. That's their possessory right. And he actually uses these words. Why don't we just sort of change the lease terms and say, you guys can stay as long as you want, but from now on, and this is what Georgia will do in 1828, 29, whenever it is, from now on, your government's abolished, your laws are abolished, we're dividing you up into 4 Georgia counties, and you are subject to the laws of Georgia. And of course, this will be followed by Andrew Jackson's passing pushing for the passage of the Indian Removal Act, which gets passed in 1830. on the deal in Indian removal, it doesn't say you have to go, but it says if you're made so uncomfortable by what Georgia has done, we will trade you your lands in Georgia, North Carolina, and Tennessee, et cetera, for lands out west on what was then the Mexican border. Now it's my home state of Oklahoma. And eventually that, of course, will lead to two major Supreme Court decisions, Cherokee Nation versus Georgia and Worcester versus Georgia. I mentioned before, Worcester, I think you'll have to read the book for why, and it becomes meaningless eventually anyway, actually reverses in part the discovery doctrine in Johnson, but it has no staying power because the Johnson majority will die, and by 1836, a majority of the justices on the court are Jackson appointees. A healthy number are by 1835, which of course is when John Marshall dies. And in 6 opinions issued between 1835 and 1842, the Supreme Court will restore the Johnson formulation of the discovery doctrine, and that will provide the legal backdrop to Indian removal. So there's another reason not to like the discovery doctrine, that it was, at least in my judgment, repudiated by its author, poorly thought through, no argument on it, and was then restored to provide a legal impetus to Southeastern tribes to be forcibly relocated on the various trails of tears. It is an execrable document from a political demographic perspective, and unfounded in much of anything, as near as I can tell. And this is the last thing I'll say, and then I'll invite questions and we'll turn it over to Bob. It's been exported all over the world. All of the major English-speaking countries with indigenous populations have Supreme Court decisions or high court decisions establishing rules, the discovery rule as articulating the consequences of European discovery, and every one of them cites the case of Johnson versus McIntosh. And that's a topic, the sort of world impact of the Johnson case, our discovery doctrine, and just European discovery in general, that Bob is going to visit with you about as soon as I stop answering questions. So that's it in a nutshell. And as I say, I'm more than happy to answer any questions if there are any.
Thank you very much, Lindsay. That's really good information, and certainly your passion is contagious in this topic. So it makes it a little easier to learn and to absorb some of the information that you were throwing out there. I know for me, myself personally, I was really interested in, I've always noticed too, I don't have a degree in history. I'm more of a natural resources guy and political science kind of guy, but it's interesting to take a look at some of the timeline with this. So in 1823, we had, Johnson v. McIntosh. 7 years later, Andrew Jackson forces removal or begins forced removal of the American Southeast of its indigenous peoples. And so I really appreciate that you brought up that the discovery doctrine, while not at all related to anything in Johnson, was very much a rationale for removing peoples from their actual lands. And so I think for many of us, we feel some of those effects, or at least we could think back on some of those pieces that our families had gone through various trials and tribulations related to the doctrine, and also removal itself. And so it's such a personal thing for, I think many people in different communities.
I should say, if I might, Nicholas, that I actually think John Marshall felt really bad about it. He comes off not looking very good. There's a correspondence between Marshall and Senator Frelinghuysen of New Jersey, who was one of the principal opponents of the Indian Removal Act, in which Marshall refers to what the southern states are doing as I think I may get the adjectives reversed, but the unrighteous combination of unholy power. And I think he felt guilty about having sort of created this, unreflectively, this doctrine that ends up being directly usable by the pro-removal forces eventually. And a reason that you shouldn't decide questions outside a case question presented because you don't get argument, and then you're just, crossing your fingers that you don't mess up.
Have you found in any of your research any glimmer of why discovery popped up in Johnson? I mean, if he tries to walk back some of what he said in subsequent cases, why did it even come up?
Yeah, well, I don't want to, okay, I'll just take a minute on this.
Sure.
I think it came up, it had been argued that the side that was hired to throw the case, which was William Winder and a guy named Henry Murray, argued that tribes had no interest, no real property interest at all. And that may have gotten him thinking. It isn't where he went, of course, we get occupancy and discovery and stuff, but that I'm guessing may have sort of triggered, he had a personal interest in resolving this Virginia-Kentucky dispute. And the problem with Virginia-Kentucky was Virginia, most of the large states didn't have any money to pay soldiers. And so Virginia recruited soldiers to fight the revolution by promising them a land out in Western Virginia once this thing is done. And the higher your rank was and the longer you served, the more land you got. And so they ended up with the Virginia militia assigning them, giving them patents, which were, this many acres of land out in, and it's lands in the southwestern corner of Kentucky, which was then Kentucky County, Virginia. And they could do this. They sent surveyors out after the war, Governor Patrick Henry did, led, it turns out, by John Marshall's dad, and they got chased out, unsurprisingly, by the Chickasaws, who said, "What the hell?" And so they stopped even trying to do this. 1792, Kentucky becomes a separate state. In the Virginia statute that allows for Kentucky statehood, there's a provision that attempts very inartfully to protect the rights of these militia holders. But it doesn't. It's a really poorly drafted, and interestingly, it turned out that it was drafted by young legislator John Marshall, again, which is why he's, culpability and why he wants to fix this mess he created, because the Chickasaws will leave 1818. Kentucky jumps in and says, it's our land to give now. And Virginia says, no, we already gave patents. And Kentucky's response, and they're fighting this out politically, is no, those patents that you gave them, because you didn't own the land, it's merely a right to purchase from the Indians, or a right to maybe acquire it now, but it's not a property right. So in other words, the militia may have a legal claim, but it's a breach of contract claim against Virginia. It's not a property claim against Kentucky. And what the Johnson-McIntosh decision gave Marshall the opportunity to do was, by finding that the underlying title vested in the discovering sovereign, that would have meant then it passed to Virginia. So when Virginia awarded their soldiers these patents, they actually did give them a real property interest that was now enforceable against Kentucky. It's directly responsive to Kentucky's argument in this dispute. And so I think he was looking for an excuse for an Indian case that would allow him to draft a rule that would give a real property right to these Virginia soldiers. And he, of course, had been a Virginia soldier, and he's the one who had been tasked as a legislator with protecting their rights in future, and had frankly screwed it up. And so that's a long answer to your question, and there's more detail, of course, sure, in the book, but I think that's what was going on here.
Thank you. And we'd have just one more question for you, since you're the one who's been talking about Johnson here. Are there any options available for relitigating Johnson v. McIntosh?
Yeah, I think so. Here's the funny thing about Johnson in US law, because the Supreme Court's, so the unanswered issue in Johnson is what is the scope of the occupancy right? What do you get to do? And over the years, that question has been answered pretty generously in favor of tribes under US law, certainly compared with Canada, Australia, and New Zealand. We don't really have lands, but Australia, there's no development rights. But the occupancy right under US law pretty much lets you do whatever you want to do if you're the tribe or tribal citizen with an occupancy right. So it's not clear that there are material differences, which in a way may make it easier to litigate. I mean, what you would do is basically, and this is what happened with the 5 tribes, by the way. When the 5 tribes were moved to eastern Oklahoma, one of the things they insisted on, because they didn't want to face the same landlord-tenant business out here, is you put in that deed that we own the underlying fee title to those lands. And so that's in there for the 5 tribes. It's to avoid this Georgia situation recurring. So we call the 5 tribes lands, as all of you may know, restricted fee lands, as opposed to trust lands where the tribe just owns the occupancy right. You could challenge Johnson and get all Indian lands just converted to restricted fee lands. And I don't think people would notice. I mean, it would, in terms of like, well, what do we get to do now? Well, it's pretty much the same stuff you could do yesterday, right? Restraint on alienation, which is a part of the Trade and Intercourse Act anyway. And that's why it's restricted fee. So I actually do think that part is doable here. And I think that there would be, you know, it's certainly less paternalistic. And by the way, I think the proper way to view the Trade and Intercourse Act is not a restriction, and Marshall says this in Worcester, it's not a restriction of the right of the tribes to sell, the restriction of the right of non-Indians to buy, right? You know, and so that's more respectful too. So I think those 2 steps would be positive. The more interesting and difficult question is, could you do it anywhere else? Like, could you get rid of it in Canada, where there would be enormous consequences because they have a fairly narrow understanding of the scope of the occupancy right, and that disappears if you're the outright owner. Could they do it in Australia? And I think those are where the battles will be fought in future years against the discovery doctrine. And the last thing I'll say, Nicholas, is everybody should look at, if you haven't read the UN Declaration of the Rights of Indigenous Peoples, because there is a provision in there essentially designed to overturn Johnson-McIntosh, or designed indirectly, it's directly designed to overturn the Teton decision. And it's the provision, I don't want to say article, it's either 19 or 49 or something, I have a 9 in my head. But it's one of the property provisions that says that tribes own the lands they hold by traditionally, which is a way of saying that they own them, right? And so that was the impetus behind the inclusion of the drafting of that language initially, and the inclusion. And so if you're going to challenge Johnson, that might be a platform to use along with this other stuff and other objections that many people have raised to Johnson versus McIntosh.
Well, thank you very much. You certainly have our gears turning now about you know, some of the things that we might be able to look at doing in the future, and hopefully in Indian country we can do something really meaningful. You know, of course, here at the foundation, we're all about that, you know, reacquiring land and owning it within our nations and peoples. And so hopefully, you know, I'll be picking your brain, I'm sure, here into the future about some of these concepts and topics. So thank you very much.
I appreciate it. I appreciate your attention, all of you. Assuming you're still there, I guess it's hard to tell when people are muted and you can't see them, but I'm going to assume that you all are there. And yeah, I'm easy to find, Nicholas. So, you know, anytime, feel free to call.
You got it. Right. Thanks a lot.
Thanks. And again, I apologize for having to leave now and for missing you, Bob, but I'll watch it after it's recorded.
Great. Thank you.
Bye all.
Okay, let's see. I am screen sharing, but I don't know how to find. Good morning, everyone. It's still morning where I'm at. Thank you for joining us and talking on this subject. Lindsay's talk was very fascinating because I've never gotten that much into the history of the case. And so to hear his take on this and to explain even more, I did know that the case was a collusive case, but what an outrage. I got involved in talking about the doctrine of discovery in 2002. Like a good professor, I answered a call for proposals to speak at the Buffalo Bill History Museum in Cody, Wyoming. It was the beginning of the bicentennial events for the Lewis and Clark expedition. And then in 2003, my tribe appointed me to an ancillary board. It was called the Circle of Tribal Advisors to the National Lewis and Clark Bicentennial. And at the time, I was an untenured professor. And I thought, boy, this sounds an awful lot like just a lot of history. And I was a law prof. How am I going to get tenure? But then I thought of the doctrine of discovery. What did Thomas Jefferson know of the doctrine of discovery? Of course, Johnson v. McIntosh is 20 years after he sent the Lewis and Clark expedition across the continent. And I even dreamt, did Lewis and Clark themselves know anything about law and history and international law and England's and France's and Spain's and then the United States claims over Indian nations and Indian lands? So I sort of went into this thinking like, well, here's the joke I made at the time. I'm not going to be here for the 300-year anniversary of Lewis and Clark, so I better take advantage of this 200-year. So I ended up writing a law review article that was my tenure piece. I turned that into my 2006 book. Since then, I have co-written a book with Indigenous professors from Australia, Canada, and New Zealand. In 2010, we wrote an Oxford University Press book, How Doctrine of Discovery, and then even Johnson v. McIntosh was applied in all our 4 English colonies. As Lindsay mentioned, where he's anticipating where this will really play out is in the courts of these other English colonies. Australia for sure has had its Mabo decision in 1992. It turned its back on part of the doctrine of discovery, part I'm going to talk about, said it was an absolute lie, and it said the courts of Australia cannot perpetuate a historical lie. So it is interesting what Lindsay said. Where would we go with these cases in the United States? I believe this was one of the listeners' questions that, Nick, you asked, but Lindsay sees it perhaps in other countries. I'm writing an article right now, folks, that I hope to finish this week about how the doctrine of discovery was used in East Africa by England and Germany. So I'm doing a comparative piece, as I already wrote a decade ago, about Spain in Chile, and Portugal in Brazil. And my argument that this international law that was around since the mid 1400s was well used by these European powers, was used here in the United States and Canada, of course, and Mexico, and is still the law today if we read Johnson v. McIntosh. So anyway, I'm going to go through some slides fairly quickly. Lindsay's explained the case to you. I have these 3 points. What did the case decide? This country, the United States, was settled on the basis of discovery and conquest. The phrase doctrine of discovery comes from Johnson v. McIntosh. I don't think the word doctrine is even in the case, but historians and the legal field has developed this idea that the doctrine of discovery comes from Johnson v. McIntosh. But in my research and in my book, I say no. The judicial branch was the last of our 3 branches to adopt the doctrine of discovery. I argue that this was well-known international law. The English, French, Spanish, Dutch used that law and those kind of arguments in North America, obviously before there was a United States. And in my 2006 book, I argue that there's vestiges of it in our US Constitution, vestiges of it in law. I'm going to show you some of the statutes. Lindsay already referred to 1 or 2 of them, where Congress adopted various elements of the doctrine of discovery. So let's just finish these points. So what did Johnson v. McIntosh say? This country was settled on the international law of European colonization. In those 20 pages that Lindsay mentioned, where Chief Justice Marshall looks back and recounts very quickly this history, he mentions the papal bulls of the 1400s. He mentions John Cabot and the French and the Spanish claims to North America. So I believe he's laying out what international law on discovery and colonization was. What did it do to indigenous peoples? Well, you can read that slide. It limited their legal property rights, as Lindsay was talking. It also limited their sovereign and commercial rights. After the doctrine of discovery, or after a European Christian country showed up with their cross and their flag and they planted it in the soil, they claimed those Indian nations as their own, as almost subjects. This is discussed in a lot of the English-speaking world, that the Australian Aborigine peoples are now subjects. American Indian and Indian nations are subjects now. and subject to the overriding power of the king, etc. So tribes, and I didn't finish my point about commercial rights, tribes and Indian peoples were expected to deal only commercially with their discovering country. And they were expected to deal diplomatically and politically only with the discovering European country. When Thomas Jefferson was Secretary of State in 1792, he had an interesting conversation with the British Foreign Minister about the Hudson Bay Company still operating in what we call the Old Northwest, Ohio, Illinois, Minnesota, Wisconsin. And Thomas Jefferson literally wrote this British minister a letter that says, those are our Indians. You can't trade with them, you can't interact with them, and you must leave. So Johnson v. McIntosh and the Doctrine of Discovery, an enormously limiting legal principle on the property rights and the sovereign rights of indigenous nations. So here's what I did in my 2006 book. I don't think this has been done elsewhere. So if I'm going to claim I ever did anything new, this is what I'm claiming. I'm putting the Bob Miller flag and cross and a claim of discovery on this. I got the idea, what are the elements of the Doctrine of Discovery? Just like a crime or a tort, what are the constituent factors of this overarching legal principle that we now call the Doctrine of Discovery? And so after reading Johnson v. McIntosh 30 times or something, I take these 10 factors directly from things that Marshall wrote in the opinion. And this is how I then have written these comparative law pieces with my co-authors about Australia, Canada, and New Zealand, with an article on Chile, and Spain, and Brazil and Portugal. And I analyze whether those European countries used these same 10 factors in asserting their claims over lands in South America. And this is what I'm doing now with Africa. Did Germany and England make these same kind of claims in what's now Kenya, Tanzania, and Uganda? So here's the 10 factors I came up with. Obviously, first, discovery. All those paintings of Columbus and all those early explorers, they're always sticking the flag of their country and the cross because of their religion. The Spanish were famous for taking a sword or maybe building a cross. When the Portuguese Pedro Alves Cabral landed in Brazil, April 1st, 1500, he built enormous crosses. He had priests with him. He said the mass. There was all sorts of a ceremony to establish this first discovery. They thought they were acquiring title and the rights we're going to talk about. What England added to this legal theory was Queen Elizabeth. In 1587 or so, she would not recognize Portugal and Spanish claims to anywhere in the world unless they were actually there with trading posts and military forts and towns. So England adopted and created this new element that became part of the law, the principle that you had to actually occupy. You can't just find something and wait 100 years and still claim it's yours. And the phrase I use, and I forget where I first saw this, a European country had to find something first, but then they had to get back there within a reasonable length of time and occupy that area. Folks, I want you to think of what Lewis and Clark did in the Pacific Northwest, in what was called the Oregon country at that time. They built a fort at the mouth of the Columbia River, Fort Clatsop. There's a replica of that fort there today. You can visit it. They occupied that area. And then within just a few years, by 1811, the great American fur trader, John Jacob Astor, built the port, the town, the trading post that's called Astoria after John Jacob Astor. Jefferson was president when he did this. Jefferson was delighted that Astor was headed out there. Jefferson wrote John Jacob Astor a letter. This is a quote, "I will give you all the support the executive can provide," period, close quote. Jefferson was desperate for an American permanent occupancy and presence in the Pacific Northwest, the Oregon country. We argued with England for 40 years over who owned the Oregon country. And if you remember James Polk as president, what was his campaign slogan? 54-40 or fight. What was he talking about? The doctrine of discovery, America's claim to the Oregon country. We were claiming clear up to the southern tip of Alaska. We were claiming all of British Columbia by that 54-40 or fight slogan. Wow, how much of American history has been impacted by this? How much of world history is impacted by this? Okay, so I ran out of room, so here's two of my elements. What did Europeans claim? Lindsay already referred to this, and Johnson v. McIntosh says that this discovering country acquired just automatically the underlying ultimate title, is the words from Johnson v. McIntosh, just by showing up and putting their flag and cross in the soil. I call it also preemption because I think Lindsay referred to this. This European claim prevented any other European country from coming there and dealing with those Indian peoples, those indigenous nations, and buying their land. I refer you back to what Thomas Jefferson, when he was Secretary of State in 1792, this is exactly what he told the British minister. You English must leave. The treaty we signed with you that ended our Revolutionary War, that's American territory. You cannot trade with nor treaty with those Indian nations, which I already told you, he said, are our Indians. What were natives left with? Lindsay referred to this too. The cases talk about the tribes had the use and occupancy right. It's a very valuable right, yes, but it's not that underlying fee title, complete ownership. You're like a tenant almost. President Jefferson, again, wrote in his diary and wrote letters that if a tribe dies out or if a tribe moves away, those are our lands. So Jefferson, and I emphasize this, 20 years before Johnson v. McIntosh, he was well aware of this international law. Don't forget, Jefferson was a full-time practicing attorney from 1767 for 7 years, I believe, till 1774 when he became a Virginia politician. And that became his full-time job, really. There are books recounting the cases that Jefferson handled those 7 years he was a full-time attorney. Half of them were land disputes, land sales, and the authors of those books said it was dealing with Indian lands, Indian title. He knew what native title, I call it, their Indian title was, and what Virginia claimed its right was, based on discovery, etc. So I've already mentioned this. Johnson v. McIntosh says this plainly, but I want to reemphasize to you, Johnson v. McIntosh, in my opinion, didn't make anything up. It was the last of our three branches to adopt explicitly the doctrine of discovery. Lindsay mentioned one of the cases. There's an 1810 Fletcher v. Peck, and I think in 1812 Meggs versus McClure's lessee, in which vague references to the very limited Indian title are just sort of stray statements in a couple Supreme Court cases. So Johnson v. McIntosh, for all the reasons Lindsay mentioned and stuff, it got adopted, solidified, became part of the precedent, the stare decisis of Supreme Court case law, but it had always been there. Contiguity. I don't think I made that word up, but when an English country or a French country had a town in one little spot, how big of an area did it claim? What lands contiguous to where it actually was in occupation could it claim? The charters for some of our early colonies, the charter for New England in 1620, James I gave his English settlers 120 English miles around their actual settlements. Now, I deleted this slide, but I wish you would take a look at a picture of the Louisiana Territory. And I've mentioned the Oregon country a couple times. Those are perfect examples of contiguity. And what Jefferson wrote in a 40-page pamphlet he wrote in 1804, while he was president, he was trying to determine how big the Louisiana Territory was. He considered it to be the drainage system, the western drainage system of the of the Mississippi River, excuse me. Where did he send Lewis and Clark? To the very headwaters. of the Mississippi to the Missouri. Lieutenant Zebulon Pike, if you know that name, he went to the headwaters of the Mississippi. He then went to the headwaters of the Arkansas. Gee, he found a mountain out there called Pike's Peak. What an odd coincidence. That was a joke if you didn't get it. But President Jefferson was trying to find out how big the Louisiana Territory was based on principles of international law, the drainage system of a river. Europeans used the same principles in Africa in their claims. Terra nullius, European countries and the United States always claimed lands that were empty. This is I mentioned the Australian Supreme Court turned down one element of the Doctrine of Discovery. This is the one they rejected in the 1992 case, Mabo versus the Queen. England always proceeded like Australia was empty. And the Australian Supreme Court in 1992 says that was a lie, a total lie then, and we just cannot perpetuate that. So Australia has been in the process since 1992 of recognizing native title and beginning to issue some titles to Australian Aboriginal groups, tribes, bands. I'm not 100% sure of the word they prefer. But empty lands, of course, if they're truly empty and there's not a human there, this is the old finders, keepers, losers, weepers, isn't it? Possessions, 9/10 of the law. We've known those since we were 7 years old, right? 8, 9, and 10, I ran out of room, so I guess these are my C elements. Conquest, actual warfare, and the Spanish talked about just war. In a legal war in which the indigenous peoples were the aggressor, or in which the indigenous people did not allow the Spanish to preach the gospel, convert people, and to take assets. Since 1532, there's been legal writings in Spain about what just war is. I see Johnson v. McIntosh hinting at a second definition of conquest, beyond just military victory. When the Europeans or Americans showed up with their flags and the cross, that was the same thing as a conquest. The Europeans acquired that ultimate title. They acquired the rights, Johnson v. McIntosh said. I don't think I have to belabor the points that Christianity and civilization have always been excuses everywhere European Christians went to be superior over the indigenous peoples. This article I'm writing on Africa Now, completely the same as it was done here in the United States. So these are my 10 elements, folks, that I used to write those articles, to do this comparative research. How did Germany and England apply their claims to colonize and to own and control these tribal peoples, natives of those areas that have been there for thousands of years? And many of those people had very extensive forms of government, laws of their own, and the Europeans show up and you're not a Christian and you're not civilized, and we need to be here in charge of you. Folks, while I'm thinking of this, think of the trust responsibility. Well, I will get to this later because I do have a slide and I'm trying to look at the clock. When did I start? Now, I take a little objection, and if Lindsay was still on here, I'd be interested in his comment. A lot of people, not just Lindsay, but a lot of people have written that John Marshall maybe began to feel uncomfortable with his Johnson v. McIntosh decision and ignoring native humanity and native rights and native sovereignty. Well, practically the last opinion he ever wrote is the Worcester decision. I'll show you in a second. He cites Johnson, relies on it. Here's the second famous Indian law case Marshall wrote. For those of you who aren't aware of this, we talk about the Marshall Trilogy, and they are the 3 cases you start teaching federal Indian law with. Johnson v. McIntosh, this case Cherokee Nation versus Georgia, 1831, and then the Worcester case in 1832. Marshall died, I believe, just 3 or 4 months after issuing this opinion. So maybe he was feeling the regret of old age. I don't know, but I just want you to see what he wrote in Johnson, in Cherokee Nation and in Worcester. He continued to cite and rely on Johnson v. McIntosh. Here the question was, literally, this is a civil procedure case. Could the Supreme Court hear this case under original jurisdiction of Article 3 of the Constitution? And so the question, if you're familiar with Article 3, is the Cherokee Nation a foreign nation? a foreign state, so that the US Supreme Court can hear its suit against a state under original jurisdiction. And the Supreme Court said no. Here's a very famous phrase, if you know Indian law. The Supreme Court says tribes are, they're states, they're governments, they're nations, but they are domestic dependent nations. And I left this other piece in there for you because this is very much related to the doctrine of discovery. They are in a ward to guardian relationship with the United States. So the court holds we have no jurisdiction to hear this case under original jurisdiction because the Cherokee Nation is not a foreign country. I think I have one more point here. Look at this reference to the doctrine of discovery. What was part of Marshall's reasoning that the Cherokee Nation is a domestic country? And there's no citation to Johnson v. McIntosh there, but that language sounds to me like it's directly from the case. The Cherokee Nation occupy a territory to which we assert an independent title. Johnson v. McIntosh, showing up with your cross and your flag, everything the European monarchs have been doing since the mid-1400s. Worcester versus Georgia, the case that some people say was an attempt at reversing Johnson v. McIntosh or something, an attempt to recognize, and it is a strong case pro-tribal sovereignty, pro-tribal existence, pro-tribes as governments, etc., governing their territories. And that's how we teach it, and that's what it does say. But does it repudiate Johnson v. McIntosh? I say no. And I think I have a citation. The case quotes Johnson, cites Johnson, and talks about discovery. This case again is sort of about the Cherokee Nation. The Cherokee were not one of the parties, of course. Discovery gave title to the country who made it. And look at the reference to what I call preemption or European title. It's a good title against all other European governments. And there's my other element. It may be consummated by actual possession. So Worcester v. Georgia, John Marshall in the last few months of his life, still citing the case, still relying on various factors and points of law from that case. And remember what I started out with, that case was old by the time it was written. This was international law from the 1400s. So let me see what time it is. I will go through this fairly quickly. I see the doctrine of discovery in our Constitution, in the Interstate Commerce Clause. The Supreme Court and those of us who practice Indian law also call this the Indian Commerce Clause. The Supreme Court admits, if you read this just on its face, this isn't taking any power from tribes. What the founding fathers were doing was just deciding, should the state governments be involved in Indian affairs or only the federal government? We had already been only allowing the Congress to deal with tribes. The Articles of Confederation, Article 9, had very similar language to this. And so the 55 founding fathers in Philadelphia, 1787, they just said Congress should have the power to control American commerce with these three governmental entities. But the Supreme Court has read into this case the plenary power doctrine, and that this provision gives Congress enormous power over the Indian nations themselves, even though if you read the text, it doesn't appear to be on that topic at all. But look at the power that Congress took under that provision, under the Indian Commerce Clause. The very first Congress enacted this law, and Lindsay referred to this. I won't read that to you. July 22, 1790. This is Congress enforcing its underlying ultimate title, to use the language from Johnson v. McIntosh 30 years later, that no Indian lands can be sold without the permission of the United States. Well, why is that? Well, because the United States is the legal owner, owns that fee title, and the tribe is some sort of beneficial owner. I think all of us on this line are lawyers. We understand this. how property rights can be divided up, ownership in property rights can be divided up. Now, folks, you probably think Congress got rid of that law like 100 years later, right? When political correctness came into play. No, that is still the law today. No substantive changes. The language is a little different as they amended it over the 200 years, but look up section 177. So I want to drive home to you today. What is, I think this talks about how, or this conference, how is the doctrine of discovery still evident and present in American law today? When we talk trust lands that tribes own, Indian nations own about 56 million acres of land in the lower 48 states in trust with the United States. Now, Lindsay mentioned some tribes own the fee title, but we call it a restricted fee title. And that's not just in Oklahoma. The Pueblos in New Mexico and a few of the Indian nations in New York also have this restricted fee title. But I think everyone agrees it's no different than trust lands. I think the United States has the same control, and section 177 still applies. So trust lands is plainly my two elements from the doctrine of discovery, that European title, now the American title, and the limited Indian title over their own lands. Individual Indians own 11 million acres in the lower 48 states, folks, in trust with the United States. They cannot sell that land. They cannot lease that land. Often they can't develop that land without first getting the permission of the Secretary of Interior. That is the doctrine of discovery, and Johnson v. McIntosh still in Indian law and Indian life today. Congress also took control over the commercial contracting with tribes. Now, they might have said they were doing this to be protective, but anyway, for those years, you can see what I summarized the act said. This act led to more Indian litigation than any act at all. My old law firm kept an entire file just on Section 81 cases and developments because it was litigated so much. Congress did amend the act in 2000, but it is still the law, but it was amended and the power of Congress was lessened a bit. So maybe now that we're in what's called the era of self-determination, Congress is trying to assist tribes to do more and more, and most tribes are happy to do that. Congress amended the act in 2000. Again, I'm looking at the clock. Almost every treaty the United States signed with tribes, and there were 375 of them that the Senate ratified. The United States put the tribe under the protection of the United States and also took control of the tribe's trade. Is that not one of my elements from the doctrine of discovery? I've already mentioned that act. There were even some of these, and Lindsay mentioned the title of these acts. They were called the Trade and Intercourse Acts, beginning with that first one, July 22, 1790. They were temporary acts. They finally became a permanent act in 1802. The whole act, which is extensive, was amended in 1834. Most of it is still the law to this day, folks. The feds took control and wanted to take control of federal affairs, tribal commercial affairs. Sometimes the tribes were for that. Stop alcohol from coming into our country, into Indian country. And that's where those kind of laws came from. But Vine Deloria himself and others have written that the United States control of these kind of issues retarded the economic development and the economic integration of Indian nations and Indian peoples into this American market. Now, is that a good thing or a bad thing? I don't know. But even someone as the leading Native intellectual, Vine Deloria Jr., has made that point. This Fed trusteeship, being the guardian, has not all, I almost said not always, well, has rarely worked out to the benefit of Native nations and Native peoples, but sometimes anyway. Okay, so I think I'm about to my last slide. There are three famous themes in federal Indian law. If this is new to you, you will have never heard of this before. Felix Cohen, the most famous Indian law commentator, Indian lawyer, worked for the Department of Interior in the 1930s. The US Supreme Court cites his treatise more than any treatise in Supreme Court history. He developed the idea that there were three overriding themes to federal Indian law, and I want to show you every one of these comes from that doctrine of discovery, from how Johnson v. McIntosh described that 400-year-old Indian law. And I've just thought of something, folks, that I meant to say long ago, and I want to say this because it's about our founding fathers. And we've always got to talk about Alexander Hamilton, don't we? And you know, sing his songs. To show how well known this doctrine of discovery was, this international law of colonization was known to our founding fathers and a lawyer such as Hamilton. In 1786, he was representing New York in a lawsuit against Massachusetts on a boundary dispute. The trial exhibit, his first exhibit for the trial, was laying out European law on colonization. And the number one point on his number one trial exhibit were the papal bulls from the 1450s and 1436 that granted Spain and Portugal exclusive rights around the world to colonize and convert. So our founding fathers, Jefferson as a lawyer, they were well aware of the doctrine of discovery, called it a different word. Jefferson often called it preemption. That's where he never used the words doctrine of discovery. That, of course, has arisen since Johnson v. McIntosh. But Jefferson used the word preemption, which I borrow for one of my elements. The rights a discovering European Christian country got when they planted that flag and cross. So anyway, sorry, I just saw my own little notes there and I couldn't help but mention Alexander Hamilton. So what did Felix Cohen say is the number one principle or theme of Indian law? Congress's power over Indian nations and Indian peoples. I gave a talk yesterday, folks, for my school on whether Indian peoples are a racial class or a political class and how the Supreme Court reviews those kind of issues. So that's relevant to this. Congress assumes power over native nations and native peoples and can do good things or bad things. And Indian peoples are deemed to be a political class. And Supreme Court review, which was absent for 74 years from the Lone Wolf case in 1903 until the Delaware Business Committee versus Weeks in 1977, federal review of acts that are either injure or help indigenous peoples as tribal citizens is not strict scrutiny because it's not a racial classification. It's rational basis review because it is a political decision of Congress operating under its power under Article 1, Section 8, Clause 3. This power, Congress can do good things or bad things to native peoples and native nations. What's Cohen's second theme? Tribes are diminished sovereigns. Now, folks, if you don't see that that's from Johnson v. McIntosh and what Europeans claimed for 400 years before that, buy my book. Anyway, so you can read that. I'm not going to spend much time on that because I see I'm getting very close to the end. But then the third great fundamental principle that Felix Cohen came up with was this trust relationship. And that's why I left that part of the quote in Cherokee Nation versus Georgia, that tribes in the United States are in a ward to guardian relationship. And again, I hope you see an analogy to those 10 elements of the doctrine of discovery. The sovereign rights that tribes automatically lost without their knowledge, their consent. The property rights, land ownership, the ownership of assets, timber, minerals, water. These things are trust assets. We use that very phrase to this day, folks, when tribes own timber, water, land. If it's on lands where that is a trust land, then we call these trust assets. The federal government is the ultimate legal owner, the tribe's the beneficial owner. So to this very day, the doctrine of discovery and those elements of mine continue to live. So my last slide is just, I've already mentioned this. This is what I'm working on. I don't know what you all know about the partition of Africa and what's called the scramble for Africa. There was, well, this is very relevant, actually. The Berlin Conference of 1885 was called to decide the rules for dividing and colonizing Africa. 12 European countries and Turkey, and for some strange reason, the United States were invited to this 6-month conference in Berlin. They ended up writing the Berlin Act, signed February 26, 1885 by all of those attendees except the United States. We got a new president, we didn't sign that agreement. What I'm analyzing is how much of my 10 elements of the Doctrine of Discovery are in that document. They called it international law. Many historians say the Berlin Conference and the Berlin Act were codifying international law of the international law of colonization. What law do you think they were colonizing or codifying, folks? I think it's obvious, the Doctrine of Discovery. So I'm focusing on those 3 countries on the lower mid-right side there, East Africa, Kenya, Uganda, and Tanzania, all 3 around Lake Victoria there, and how Germany and England colonized, justified their colonization, justified their rule, justified their exploitation of the peoples and the lands and the assets. And so that's what I'm writing right now. So that's why I have that map on there. But anyway, thank you for attending. Thank you for listening. And I'm certainly willing and happy to take any questions.
Thank you, thank you, Bob, not Lindsay. Lindsay's gone already.
He left.
Yeah. You know, that was such a wonderful discussion that you both had given, but, you know, definitely an issue such as this, it's wonderful to hear such passion coming from people, because, you know, we need to be able to talk about these issues and to better inform attorneys, law clerks, judges about a whole host of these philosophical and historical pieces that have big implications for Indian law and land today. You know, so thank you very much for your role in doing that. I do, you know, have a question about treaties. So when Europeans started to come over to this continent, you know, they would sign treaties with tribal nations, Indian nations, to secure land rights, to secure economic partnerships. But then somewhere along the way, especially post American Revolution, the interest or the priorities in treaty making changed. And then, you know, we get to the 1823 case, we get to discovery, and then the subsequent cases in the 1830s and removal. And so I'm just wondering, you know, what changed in American history that moved the treaties from, you know, this acknowledgement that, you know, these are real nations, sovereign nations who could sign their own treaties with the governments, European nations, to, you know, post-American Revolution, where a lot of these treaties were then signed to, you know, remove people from different areas. And in fact, you know, leading to Cherokee v. Georgia in 1831, where, you know, the court said, no, they're wards and we're the guardian, you know. So there's a lot of change that happened in a pretty big amount of time. But I'm just wondering if you had any kind of feedback or any thoughts about this change.
Yes, a lot of historians and legal commentators have commented on this. I have seen a little pushback, so it's not 100% universally accepted. But the treaties that were signed early on were pretty favorable for tribes, because guess who had the military power, the population dominance maybe. So the very first treaty the United States signed with tribes, folks, was in 1778 with the Delaware Nation. It literally invited the Delawares to form a confederacy of tribes and maybe join the United States as a state. Now that's about as, now it was a qualified question because it would be up to, or a qualified offer, because it said Congress would have to agree whether to let you in as a state. Treaties thereafter never repeated that promise, but the Cherokee Treaty and treaties with my tribe in 1786 and 85 offered the tribe to send a representative to Congress. The Cherokee Nation has been reviving that. If you've been watching the news in just the last few years, Cherokee Nation of Oklahoma has named a representative. I hesitate to say it's Kim Teehee, but I think that is correct. And they want her to be allowed as a deputy to Congress to fulfill that promise. And what you mentioned, Nicholas, is that then as the power dynamics shifted, the treaties became more and more one-sided. Most people say that after the War of 1812, when the threat of England from our defined geographical boundaries was gone, that after the War of 1812, treaty making became very one-sided. I've seen one or two commentators say that's not correct, but I think the vast majority accept what I just said. Now, let me add one thing, though, that takes you back. George Washington, when he was general, September 7, 1783, he writes a very influential letter of advice to the Congress. Anyone that wants to see this, it's called the Savage's Wolf Letter. It's about a 4 or 5 page letter. Indians are mentioned in the last about 3 or 4 paragraphs. He compares Indians to animals. He says they will disappear and we will just get it all. That's the summary. I want to be nice to George, but I would like you to read that letter because this is where I should have a slide on this for you. He says the savage is the wolf. So he compares Indians, who were called savages, of course, to wolves. And then the very next sentence, and I think I have a quote, he says, both being beasts of prey, though they differ in shape. That's quote, close quote. He compared Indians to animals. He said, we are both beasts of prey. You know what prey is, right? Being hunted, though we differ in shape. Now that's about as blood-curdling a thought that one can think. But that's what General George Washington advised our Congress in 1783 should be the Indian policy. So Nick, your question showed the United States got away with what it could. If it had to make nice promises, it played nice. George Washington and others said doing treaty making is a lot cheaper than war. I already have a quote out of Africa. I forget if it was Germany or England, but some minister said treaty making is a lot cheaper than warfare. So it's a continual pressure, continual attack, removal, removal, removal. And don't forget, it's not just the 5 tribes, the 5 civilized tribes they're called. My tribe was removed from Ohio in 1832. Lots of native peoples were forced to the Oklahoma area. I see somebody asked in the chat the title of my article. So here's the piece of paper I'm working on right now. There's my title. I hope to have a finished product in a week. It will be put on SSRN. Someone asked where will it be published? Well, we don't know till I send it out, but that's what I'm working on right now.
Great. And Bob, whenever that's all published and done, certainly, share it with me and we could let the interested parties, give them the direct link to that article.
Well, my articles about Chile and Brazil are, of course, already on Westlaw, and they were published back in 2011.
Thank you. And we have another question here. This participant says that my tribe is an executive order tribe. How do we compare to treaty tribes, and is there a designation? Military?
Yeah, I didn't catch what that last part means. Executive order tribes, according to the casebook I use to teach Indian law, are the same as treaty tribes today. There was a time, perhaps there was a question whether their lands were as protected as a tribes whose reservation was created by treaty. But I think all the commentators agree that executive order tribes have all the powers of a tribe created by treaty or a tribe created by an act of Congress. So whoever asked that question, if you have something more specific that you were referring to, please feel free to contact me later or to ask it here. But I think that's what you were asking about. And I do think the law and all commentators who write on Indian law would say that there's no difference these days. It's just a different entity created your reservation. Your rights are the same as a government and as the owner of your reservation in that limited Indian title that I've been talking about.
Thank you. And, Bob, if we get any sorts of questions after the webinar, I'll be sure to forward those on to you for a more thorough answer. We have one more question that looks like that has come in. Do you see the plenary power strengthened or lessening over time through court decisions, especially in these, quote, enlightened times?
I do not think the plenary power has changed. So whoever asked the question, I'm interested what case you're literally thinking of. We are living and have since the early 1960s in what historians call the era of tribal self-determination. Congress is seemingly mostly supporting tribes taking over their business, tribes conducting and operating federal programs. We all know the 1994 Tribal Self-Governance Act, the 1975 Tribal Self-Determination Act. It's a policy of Congress to let tribes run their own business. President Nixon said this in 1970. Lyndon Johnson said it even a few years before that. So the plenary power is being applied in a kinder, gentler way now. But is that a permanent change? And is it a change to Congress's power? And that's what I think the question was. And I need to know what case you might be referring to. I do not think anyone thinks Congress's power is less than plenary power allows for, and our 240-year history has demonstrated. It's just that we've had a Congress for the last 60 years that is pursuing this self-determination policy.
Thank you very much. So at this point, we don't have any other questions, although again, Bob, they might come in after the fact here, and we are beyond our limit of 1:30 Central. So the foundation would like to thank you very much for your participation in today's training. We do believe that this is going to be beneficial to attorneys, law clerks, and judges out there who really should know and have much better information about how to handle Indian cases going forward. So thank you again.
Thank you for inviting me, and thank you all for listening, and for the Land Tenure Foundation for hosting this. Thank you very much.
Thank you.